In May 2016, the European Union shook the world of data protection by making the GDPR announcement. So what is GDPR? GDPR is short for General Data Protection Regulation. In the past, data protection was a directive from the European Union to ensure that there is a standardized way of processing individual data of data subjects residing within the European Union. So what's different? Well, it's no longer a directive. It is now a regulation. Firstly, let's see what the difference is between a directive and a regulation. A directive is an act issued by the EU to its member states to achieve a particular result. How the end goal is achieved is not dictated in a directive. Due to this, each member state could interpret and implement a directive in different ways, so long as the end result is achieved. A regulation, on the other hand, is self-executing. In other words, there is no room for misinterpretation or personalisation of the rule between the member states. The EU is so keen to strengthen the data protection regulation that it goes as far as to say that the protection of personal data is one of the fundamental rights of an individual. So, anybody in any part of the world dealing with customer data from the EU are subject to the new regulations, and it's due to come into effect on the 25th of May 2018. For this session, we'll focus on the 12 key aspects that you'll need to be aware of. Listen carefully, as any failures could cost you or your company up to 20 million euros, approximately $22.3 million, or 4% of your annual turnover of the previous year. The EU's focus is to unify and take back control of EU citizens' data protection, and has made these significant changes to suit the modern, digitally connected world. So, if you are a small-time data processor in India or a global data controller in the Silicon Valley, you are subject to the new GDPR if you handle an EU citizen's data. So that you can prepare for the upcoming GDPR changes, here's 12 steps you'll need to take. 1. Create awareness. 2. Know your data. 3. Review your policies. 4. Know your data subjects' rights. 5. Know what's changing with subject access requests. 6. Justify why you need the data. 7. Know what's changing with consent. 8. Know how to handle children's data. 9. Know how to handle data breaches. 10. Know how GDPR affects software and digital systems. 11. Appoint a data protection officer. And 12. Know your data regulator. If you are the key decision maker in your organization, then you're already on your way to becoming compliant under the new GDPR. If not, you'll need to start getting the buy-in from key people in your organization, especially if you're a large organization, as these changes could have a financial implication. Let's start with creating awareness. Following on from the previous section, your first step is to create awareness about the upcoming GDPR changes. Implementing the GDPR could cost you a fair bit of money, especially if you're a large organisation. You should use this time, yes now, to prepare for the GDPR changes. Don't leave your preparation until the last minute. All it takes is one disgruntled customer and all your hard work could go to waste. Before you go trying to change the world, you need some empirical data, numbers, costs, etc. to justify an organisational change. So let's do just that in the next step. Know your data. Do you know your data? Do you really know your data? Do you know where your data is coming from and what data you hold on your customers? Start by documenting where your data comes from, what personal data you hold about your customers and who you share this data with. This should give you a broad overview of what data you hold and where it comes from. At the very least, embarking on this exercise will help you conduct an information audit within your organisation. Remember, the GDPR's accountability principle requires you to demonstrate that you adhere to the data protection principles. Review your policies. Whether you're a small company or a multinational, you'll need to review your data protection and privacy policy. If you currently have a privacy notice on your website or within your terms and conditions of business, you'll need to review these. Why? Because under the GDPR, there are some additional things you'll need to tell people. You'll need to explain the legal basis on which you are processing the data, that is, why you are processing the data, how long you are going to hold the data for, and if the individual thinks that there is a problem in the way you are handling their data, they need to know their rights to complain to the Information Commissioner's Office. Remember, the new GDPR requires the information to be concise and easy to understand. Know your data subject's rights. The 6 key data subject rights are: 1. Right to access the data you hold about them. 2. Right to accuracy of the data held. 3. Right to be forgotten. 4. Right to prevent direct marketing. 5. Right to prevent automatic decision-making and profiling. 6. Right to data portability. Sounds familiar? Well, most of these are already applicable today. GDPR enhances the existing individual rights to cover a much wider scope as opposed to introducing altogether new ones. Think about how you'd react if someone asked to have their personal data deleted. Would your systems help you to locate and delete the data? Who will make the decisions about deletion? So what's new here? Well, the right to data portability is new. This is an enhanced form of subject access requests, where you have to provide the data electronically and in a commonly used format. Many organizations will already provide the data in this way. If you use paper printouts or an unusual electronic format, now is a good time to revise your procedures and make any necessary changes. Subject access requests. Great! Now here's one of the most important changes coming your way, the subject access request. Under the GDPR, these rules will change. Currently, companies and businesses can charge for a subject access request and can take up to 40 days to complete a request. This is changing. Under the GDPR, you cannot charge for complying with a subject access request, and you only have 1 month to comply with the request. There is also a new provision where you can refuse a subject access request. The 2 instances where you can refuse or charge for a subject access request are when the subject access request is unjustified or there are excessive subject access requests from the same individual. However, you'll need to have adequate policies and procedures in place to demonstrate why a subject access request had met either of the 2 criteria. You will also need to provide some additional information to people making requests, such as your data retention periods and the right to have inaccurate data corrected. Justify why you need the data. Okay, so you know where the data comes from, where it's going, and what data you hold about your customers. That's great. Now let's think about, why are you collecting or processing the data? Under the current law, there is no need for you or your organisation to prove why you are collecting and or processing customer data. Under the new law, you'll need to prove your legal right. Why are you doing so, and under what authority, to collect and process customer data? Furthermore, under the new GDPR, your privacy notice and subject access request communications need to specify your legal basis of processing personal data. Once again, remember to document this as part of the accountability requirement of GDPR. Know what's changing with consent. Great! By now you should know what data you hold, why you hold it, how you use it, and where it's coming from and going to. Now we'll look at consent. There are a few key points for you to note when it comes to consent. Like the existing DPA, the GDPR requires consent to be freely given, specific, informed, and unambiguous. So what's changing? Well, while there is no change to the actual consent obtained, the GDPR makes it significantly more difficult for organisations to obtain valid consent. What does this mean? The existing DPA only states that the data subject must signify consent. This could be implied or an opt-out type of consent. The GDPR makes it clear that consent requires a clear affirmative action by the data subject. The valid consent must then be documented and an audit trail maintained by the data controller or processor. In a nutshell, ensure that data subjects have a genuine choice. Avoid providing a product or service conditional to consent being given. For example, complete this survey to read the article. Limit the data processing to a specific context. Take significant extra steps to ensure that data subjects are properly informed of the purposes for which their personal data will be used. Any consent obtained by not telling the data subject why the data is being collected may not be valid. Remember, silence or inactivity is not consent. Organisations cannot use this form of consent anymore. Handling children's data. For the first time, the GDPR will bring special protection for children's personal data, especially when it comes to commercial internet services, for example, social networking or video sharing sites. As a direct result, you'll need to think about putting systems in place to verify an individual's age. Remember, consent needs to be verifiable, and the privacy notices are relevant to the audience. For example, if you're writing it for children, they must be able to understand it. Know how to handle data breaches. You should make sure you have the right procedures in place to detect, report, and investigate a personal data breach. Some organisations are already required to notify the ICO when they suffer a personal data breach. However, under the GDPR, all breaches where the individual is likely to suffer some form of damage, such as through identity theft or confidentiality breach, should be notified to the ICO. You should start now to make sure you have the right procedures in place to detect, report, and investigate a personal data breach. This could involve assessing the types of data you hold and documenting which ones would fall within the notification requirement if there was a breach. In some cases, you'll have to notify the individuals whose data has been subject to the breach directly. For example, where the breach might leave them open to financial loss. Larger organisations will need to develop policies and procedures for managing data breaches, whether at a central or local level. Remember, a failure to report a breach when required to do so could result in a fine, as well as a fine for the breach itself. GDPR for software and digital systems. There are two aspects of the GDPR you'll need to be aware of when it comes to software and digital systems. They are privacy by design, privacy impact assessments. It has always been good practice to adopt privacy by design approach and to carry out a privacy impact assessment as part of this. Privacy by design and data minimization approach has always been an implicit requirement of the data protection principles. However, the GDPR will make this an express legal requirement for you and your organisation to follow. Note that you do not always have to carry out a PIA. A PIA is required in high-risk situations, for example, where a new technology is being deployed or where a profiling operation is likely to significantly affect individuals. Note that where a PIA, or a DPIA as the GDPR calls it, indicates high-risk data processing, you will be required to consult the ICO to seek its opinion as to whether the processing operation complies with the GDPR. Appoint a data protection officer. The GDPR will require some organisations to designate a data protection officer. For example, public authorities or ones whose activities involve the regular and systematic monitoring of data subjects on a large scale. The important thing is to make sure that someone in your organisation or an external data protection advisor takes proper responsibility for your data protection compliance and has the knowledge, support and authority to do so effectively. Therefore, you should consider now whether you will be required to designate a DPO, and if so, to assess whether your current approach to data protection compliance will meet the GDPR's requirements. Know your data regulator. If your organisation operates internationally, you should determine which data protection supervisory authority you come under. The GDPR contains quite complex arrangements for working out which data protection supervisory authority takes the lead when investigating a complaint with an international aspect. For example, where a data processing operation affects people in a number of member states. The lead authority is determined according to where your organisation has its main administration or where decisions about data processing are made. In a traditional headquarter and branches module, this is easy to determine. It's more difficult for complex, multi-site companies where decisions about different processing activities are taken in different places. In case of uncertainty over which supervisory authority is the lead for your organisation, it would be helpful for you to map out where your organisation makes its most significant decisions about data processing. This will help to determine your main establishment and therefore your lead supervisory authority. Well, we've just about run out of time and covered the 12 basic steps you'll need to take to get ready for the GDPR.